Hello, this is Daniel Martin, criminal defense attorney in Fresno, California. One of the things I enjoy about my job the very most is answering questions that people have about the law. I like seeing a person learn new things and teaching people, and so I automatically am drawn to an opportunity where I can help people understand the law, learn about the law, and empower them so they know their rights and they know what they're up against if they're facing allegation of crime. Over the years, I've answered thousands of questions. I'm not sure how many, but many questions about the law. And there are some reoccurring questions that come up over the years. So I've taken the time to answer some of the most popular questions on my site here at Valley Justice under their frequently asked questions tab. That's where this video is. If you follow underneath this video, you'll see questions about expungement, where I answer questions that people have about how to clean up the record, get a case dismissed. It's a relatively straightforward process, but there are some technical things that have to be done and some information and forms have to be collected, and an attorney can help you. I do those for people, help them clean up the record, and I've seen a lot of people go on after having a conviction expunged and obtain the job that they were trying to get for years, or some licensing that they were trying to get because they were able to get a conviction expunged. So I also answer some questions about possession, because that's a very common question about constructive possession and actual possession. And just briefly, I've also written about it, but the most common misunderstanding is the law recognizes two types of possession. Actual possession, which is the kind of possession that a regular person on the street thinks of. So a person possesses things that are in their pocket, or a lady possesses things that are in her purse when she's carrying her purse. The law also recognizes constructive possession, and that is the knowledge of the existence of an item and the right to control it. So it's much broader than actual possession. The classic example I give is if I was to give a piece of contraband to somebody and told them that to bring it to me if I call them later on, if that person was on the other side of the town, I would still be in constructive possession because I know who has the item, it's the person I gave it to, and I have the right to control that because it was mine and he was just holding it for me. So I'd be in constructive possession of that contraband even if it's on the other side of town. As a result of the law of constructive possession, more than one person can possess an item at the same time. Frequently I get the question, well, I was in a car with two other people and they found a piece of contraband. My co-defendant already pled, so since he's pled to it, well, why aren't they dropping my case? And I have to answer, it's because their theory is that the three of you possessed it, or both of you possessed it at the same time. And it's difficult to convey the idea that the prosecutor is going to want to punish the most number of people for the longest period of time. So just because your co-defendant pled doesn't mean they're going to dismiss it against you. It's a factor that will go into the case, but it doesn't mean the case will be dismissed. And speaking of cases being dismissed, one of the items I cover the most in my frequently asked questions column has to do with Miranda rights. Probably the most common misunderstood concept has to do with a case called Miranda v. Arizona from 1966. In that case, the person wasn't advised that they had the right to remain silent, and so they gave a statement to the police, and then they were convicted, and their attorney appealed the case and went to the Supreme Court, and the Supreme Court held that people need to know that they have the right to remain silent. They have the absolute right not to speak to law enforcement. They don't have to give a statement, and that their refusal to give a statement cannot be used against them. If a person has not read the Miranda rights, it doesn't mean the case gets dismissed. In fact, frequently people are arrested and they're not read the Miranda rights. There's nothing in the law that says that you have to be read your Miranda rights or the arrest is illegal. Nothing like that. The Supreme Court case that dealt with Miranda said that if law enforcement does not advise a person of the Miranda rights and they make a statement while they're in custody in response to interrogation, then their statements can't be used in the prosecution's case in chief. So, one, there's a lot of conditions that are required. And then 2, even if the person has not read the Miranda rights, the only remedy is that their statements can't be used in the prosecution's case in chief. That's the first part of the case. There's actually another part that the statements can still come in. So Miranda is not really the case that helps defendants the most in the United States at all. It's rare. In fact, as a criminal defense attorney, if I come across a case where Miranda does make a difference, I talk to my friends, my fellow criminal defense attorneys, and I mention, hey, there's this case where Miranda made a difference. Very rare. So that's something I cover here. You're welcome to read on, get some more specifics about that. And I'll be adding to this column, both with video and questions as time goes on. Thank you.